Hello and welcome to On the Record, where we go behind the headlines for hard-hitting analysis with the experts. Well, News Limited CEO Kim Williams pulling no punches this week, slamming the Communications Minister Stephen Conroy's proposed media reforms as a direct attack to now crush free speech, innovation, investment and job creation, unquote. Alongside the headline-grabbing move, though, to set up a public interest test with so-called diversity as the stated litmus test, the little-discussed notion of a privacy tort was consigned to the too hard basket, effectively sent back to the Australian Law Reform Commission for a third time for review. What then is likely to change? What, moreover, can we learn from the way that the US media functions against its own set of legislative checks and balances? Well, my guest today has unrivaled experience when it comes to this area. Certainly, let's just run you through his case history. He's practiced and continues to specialise in First Amendment issues, conducting over 1,000 jury trials in the United States across his near 40-year career. Lead trial lawyer too in the landmark Meinhold versus US case. That's where the right of gays to serve in the US military was first established. He represented the chief of police in the aftermath of the LA riots after the Rodney King trial, and in a firearms case that involved the right to bear arms, represented Colt firearms in a dispute with the LA police. Dr. Harry Melkonian also lectures on the US Constitution at the US Studies Centre at the University of Sydney. Joins me now. Warm welcome to you. So much to talk about, and to get a sense of just where things start to be relevant for our audience, let's understand what is, I suppose, a given in the United States, and that is a right to privacy that is, in real terms, something that we take for granted, but there are bigger picture considerations that mean that even that right is cut down at some point. You have a constitution, a First Amendment, that says that governs everything. How important is that, and when's it tested practically?
Well, it works actually fairly efficiently. There's overriding all of the other laws, including the privacy laws, which have been in place for a long time. There is a First Amendment right that people who are in the public eye have a much lower expectation of privacy. And what the courts look at is, what is the expectation of privacy for this person, and what is the public interest? And depending on the public interest, there may or may not be a right of privacy. So the First Amendment really is sort of a cloud over it.
I want to then understand how Australia begins to grapple with putting down some markers when it comes to who can do what, because, if I'm wrong, there is no umbrella right enshrined to even free speech. So the very trade that I'm involved in doesn't have anything in statute that says this is protected fundamentally. So even as we're talking privacy, as the government has this week, it's against a backdrop of no fundamental rights enshrined for media.
That's right. That's a fundamental issue that's been raised as a criticism of proposed legislation from the Reform Commission, because unlike, it's not just the US, it's Canada, it's the UK, it's all of Europe and New Zealand, where there are either statutory or constitutional rights of freedom of speech. We're talking about a right of privacy impeding free speech, but there is no corresponding right of free speech, so that the exception has the potential to overwhelm what should be the rule.
The reason that it's important to make these distinctions is because front and centre to what was announced this week was, as you know, the imposition, as it were, of a new body, a public interest advocate, that would purport to make decisions not just on mergers and acquisitions, but perhaps in a bigger picture sense, picking winners and losers from inside the industry, determining that material didn't necessarily pass the test of diversity. How dangerous is that against a backdrop of nothing really to fall back on for the media?
Look, on its face, someone could say, well, it doesn't look like much of anything. But the biggest danger in matters relating to the press and the speech is this concept of chilling free speech. And that is, you don't have to overtly threaten it, but if you have some governmental power, will the media be less likely to say and do things that offend the government of the day? And it's a real concern, particularly when you don't have this embedded underlying right of free speech. And I think that's the legitimacy of the concern that's been raised, is saying, wait a minute, we're appointing this very powerful person, the government is appointing this powerful person, supposedly to be looking at all these other things, but he's looking at so many different other things. Maybe what we say and do will somehow figure into it. And since we don't have this constitutional right or even a statutory right, is this going to chill free speech in this country? And it's a legitimate question to raise.
Has the pendulum, in your view, from the welter of what you've seen firsthand in courts, when it's been that contest between media and authority, has the pendulum, though, swung, if anything, too far in the other direction? You'd be all too familiar with what happened during Watergate. We've been speaking about this one even off air, where life can be made very difficult. But equally, is there not an onus on our parts to actually be pretty damn sure of what we're doing, above and beyond the way we're doing it now?
But there is an effective regulation of the press. Besides the press councils, if you defame individuals, they do not hesitate to call you on account.
But at some considerable cost for the plaintiff.
That's true.
And, you know, proving that is another thing. It's not like, as a doctor, I can have demonstrably blinded you in an operation, or, you know, given you lifelong, you know, rendered you in a wheelchair. Very hard, very amorphous concepts of reputation under discussion with the equivalent media argument.
But it's a dynamic thing. It's always in a state of flux from time to time. And I think in a democracy, we simply have to accept, for democratic society to work, sometimes things don't go precisely right. What do you want to do? Overregulate and control the speech too much, or now and then have excessive speech?
You talk about the overregulation, yes, because here we have a law reform commission that not just once, not twice, but now for the third time is being asked to look afresh at a tort of privacy. So having established, as we have, there's no overarching right of free speech. So in a sense, are they putting the horse before the cart by now focusing on privacy? The overly prescriptive nature of what might emerge, how problematic is that? If you try to set things out black and white.
That is exactly the problem. They've set things out black and white and tried writing something that I would put, it's more like a tax code in its level of detail, and doesn't recognize, as has been the case in other countries, that you have to let courts, this is what courts do very well. They balance interests extraordinarily well. That's the role of the judicial branch. Are you
basing that on the jury system and the having been through that jury trial system so many times to see those 12 good men and women at work, or is it down to a judge? Is there the same effective decision making?
It's down to the judge.
Right.
It's down to the judge. I mean, juries make ultimate decisions, but on some of these fundamental questions as to newsworthiness and things like that, judges.
Are you comfortable with the judiciary being in touch in quite that way with every man, quote unquote?
Well, look, we accept the judiciary as part of government.
Oh, well, and yet it's very much separate, is it not?
And very much separate.
Yes. And that wasn't a Freudian slip, I take it. I mean, because it shouldn't be part of government, should it? I mean, you've got those. I mean, the media is the fourth estate. So you have your executive, your legislative, and your judiciary, right?
Yes.
Very much separate.
And again, in a democratic society, we have elected to give our independent judiciary powers to scrutinize what the political branches are doing. And we have to put a faith in that. You undermine everything if you say, well, we don't trust judges. Well, if you have to trust somebody at some point.
Well, could the advocate role, as mooted, be something a member of the judiciary might well carry out? Could we confidently, therefore, place the responsibility for those decisions in the hands of a judge?
No, and I'll tell you why. Judges are trained and are there for the purpose of deciding disputes. They're not administrators. They're not regulators. They're not equipped for that. They can't be setting rates. They can't be ruling on these things. What they can do is evaluate for lawfulness decisions that are made by regulators. And this is a problem that's been pointed out with this proposal, is that the decisions of this advocate are not subject to review by the courts. And that is one of the fundamental things, because almost everything that government does, including an act of parliament, the high court gets to look at. And here we're appointing someone with all this power over the fourth estate that we all need, and it's not going to be subject to review by the courts.
The other point that was made, allied to that one, Harry, was that it would be, and I'm referring to Kim Williams' statement, CEO of News Limited, 14th of March, quote, retrospective. He or she can overturn deals that took place before the new laws came into force. What kind of precedent is there for that kind of a backward-looking behaviour to be undertaken?
That's relatively unprecedented to be able to do that. To what, again, is that more of something to chill free speech? Is it a threat that might never be exercised, but in the meantime, is it something that would go into an editor's mind? Do I really want to say this about the government right now? Or maybe I'll report on a new movie instead.
Harry, back to your career, being given briefs, acting for clients and all the rest of it. If you were asked to take this one on for the media as a whole, what would you be doing in constructing a case to effectively challenge the government front on in court?
It would be, the challenge would be, the High Court of Australia has said that under our Constitution there are rights of political speech that cannot be excessively regulated. And an argument might be fashioned, but it would be difficult, that when we're dealing with media, especially newspapers, regulation of broadcast media is pretty well established, but regulation of newspapers is something that governments have generally stayed away from. So they are going into dangerous ground for government. And I think you could argue to a court that every red flag should be up when we start talking about government tinkering with the print media. And that, are we setting something up where there is a likelihood that freedom of speech relating to criticism of government, there's just too great a risk?
Strains of Nixon, about this, how was that dealt with when licenses came up for renewal around about the time of Watergate and life was made quite difficult for key players? Was that a tipping point on reflection? Oh,
it was very important because it really happened. It's a case in point. During Watergate, when the print media was giving the president a very hard time, particularly the Washington Post, they owned a TV station that had to have renewals of its license, and he instructed the Federal Communications Commission to hold up the renewal process. And again, he couldn't make, what the idea was, let the Post know that their TV station is in danger, with the idea maybe their editorial policy might soften a little bit. So it's proof of what this type of regulator can do without ever saying a word. Without ever saying a word, you can exert enormous governmental influence. And it really happened. And it was 20th century. It wasn't 100 years ago.
What's it like being away from it all? I mean, you are and you aren't. You're still soaked in it. But the cut and thrust. What's the biggest thing you let go of at that point?
That's really hard to put your finger on. I still try to stay involved in things, but yes, clearly it's diminished. But I'll tell you, I'm having much more time to write and reflect and try to make a positive contribution, and that's what I've been doing.
With the next gen of those who'll be called, of course, through your work, amongst other things, at the US Study Centre, lecturing on this very same topic. We wish you well, and thanks for your insights. Appreciate it.
Thank you.
Dr. Harry Melkonian there from the US Study Centre and celebrated trial lawyer, First Amendment guru par excellence.